We're nicely joined with Lewis Hastie from BRM Solicitors. Lewis is director over at BRM Solicitors and is going to be talking to us today about contentious probate, which seems to be becoming bigger and bigger and bigger and bigger. So we're going to be talking about lots of that. Just so we do a little bit of real basics to start off with. A lot of this won't be around the Mental Capacity Act, the test. It'll be under Banks versus Goodfellow. So just so Lewis doesn't have to repeat it over and over again, mate. Banks versus Goodfellow, you need to understand the extent of your estate. You need to be able to, you need to understand what a will is. You need to understand the effects of the will. You need to understand the extent of your estate, so how much money have you got? Then you need to be able to make the decisions within the will and understand your moral obligations. And then this bit I love, you can't have an illness that perverts your sense of right or prevents your natural faculties, which sounds grand wild, doesn't it?
Or poisons your affections, yes.
And then there's the golden rule that an aged testator should have their capacity assessed before going forwards. I just wanted to cover that because if not, I know somebody will ask that later down the road.
Yeah.
And if we get confused over the MCA, which happens quite often actually, we still get people coming to us saying, why have you done it on this and not on impairment of the mind or brain?
They do sit alongside each other. I mean, that's been decided in case law. Clitheroe versus Bond explored it quite recently. But yeah, you've got the MCA obviously, which is being able to understand, retain, weigh up information and then communicate your decision. Those can be relevant, but obviously Banks versus Goodfellow is specifically for wills when you make a will. And it's interesting, that came from a very old case, Banks versus Goodfellow, where the chap in question, he'd been in, I think back then it would have been a lunatic asylum, nowadays it would be being sectioned, but he was having some paranoid delusions and he left the institution with some fixed delusions. And I believe in that case it was decided that they had not actually affected the decisions he'd made when he made his will. But it drew a line in the sand that if you are having fixed delusions of some kind, which is going into the fourth limb of the test, then and that actually affects the way in which you leave your estate, then that can render it invalid due to lack of capacity. Yeah,
I mean, the best example I ever got was a young lady who had schizophrenia.
Yeah.
And it was great because she was lovely and she really controlled her voices and managed it all really well. But the only thing she couldn't get over was her voice had told her that her brother had been replaced by a robot.
Right.
And she couldn't disprove it.
Yeah.
So therefore she didn't want to leave him anything in her will because her brother, that wasn't her brother anymore. And she kind of didn't believe that, but she couldn't disprove it. And it was really, really, I mean, lovely, interesting to talk to her about it as well. But we're already, see, I told you we'd end up going off track. This is how these things happen. So trends within probate, contentious. Do you want to explain what contentious probate is?
Yes, of course.
Because most of the people on here, I'm guessing, are will writers, probate solicitors. So what's the difference between a probate solicitor and a contentious probate?
Well, generally speaking, I mean, probate solicitors will deal with somebody's will, help them manage their property, create trusts for them, for example, maybe even do things like powers of attorney. And then, of course, after somebody has died, a probate solicitor will quite often help the executor of their estate, or if there's no will, the personal representative, to get a grant, to do the estate accounts, to deal with certain parts of the administration. Sometimes they can be professional executors themselves. So it's really I suppose the functional side of things, helping people get their affairs in order.
So they go from creating that will all the way through to supporting and executing.
Sometimes, Sometimes it is literally just a one-hit wonder. They'll do a will for somebody, and that will is then dealt with when the time comes by the people who are charged with that responsibility. And yes, sometimes that if it's a repeat client or they know the family well, they'll be the go-to for all of those sorts of things. Whereas contentious probate solicitors like myself, we tend to deal with things after the event. After somebody has died, when there is an argument of some kind over their will or over their estate. And it doesn't just include contentious wills, but that is quite a big part of it. There are other things we can do. Inheritance Act claims, for example, either bring them or defend them. Somebody's been left out, the will's not a problem, but they want to try and get something because they've been reliant on the deceased person. Alternatively, if there's an
So
argument,
that could be somebody like a disabled child.
yes,
or
yes,
something
like that, or a surviving spouse. Sometimes there are
Okay.
people who actually don't provide very well for their spouse, or someone that's lived with them, a cohabitant of 2 years or more.
We do
that
see
sort of
those
thing.
quite often actually now
Yeah.
when we're
Yeah.
assessing capacity, that the second wife, the second husband won't be included in the will, apart from
Yes.
maybe a right to remain living in the property. And that will be the most that they receive.
Yeah, sometimes, well, as I say, Inheritance Act claims, there are lots of them, but I've found there's a big difference between a spousal claim and a claim from somebody who, a child of the deceased, for example, particularly an adult child, because the level of need, the level of dependency is obviously very different between the two, unless there are specifically unique circumstances, such as somebody with a lifelong disability who's been reliant on their parent for most of their adult life. That's obviously a very very prevalent case. But definitely, if it is a surviving spouse, I think that it's the case of Lillyman. It provides that essentially the court imagines there was a divorce and looks at how it might have been if there were a divorce as the starting point. It's not necessarily the outcome, but it will certainly be the starting point in those sorts of cases.
So I get it. So if when the person's deceased, they don't. Well, actually, if you were getting divorced, what share of
what might you have got if you brought ancillary relief? I mean, I've seen it a couple of times recently because there are some people who've separated from their spouse but not gone through a divorce yet, and they make a new will because that's kind of what they're encouraged to do at that point. But they obviously don't provide for their spouse, and they haven't completely broken apart. They haven't divided up their property, or maybe one was still living in the matrimonial home that the other owned, and that's the sort of situation where an Inheritance Act claim can be the solution for somebody.
I think we're going to have to do a whole Nellie on the sofa on inheritance tax.
We have got a bit off piece, haven't we?
No, it's genuinely, it's really interesting.
But that's the original question. Yes, that's one part of contentious probate. Contested wills is a huge part of it, and sometimes you get things like arguments between executors or disputes between the executor and beneficiaries about how the administration is being dealt with. And very occasionally you get a case where you have to rectify a will if it's not been quite drafted correctly.
It's not that it's...
That's opening up a different can of worms, I think.
It's not that it's going to impact on who gets what or anything like that, just the language of it?
Yeah. There was a case last year, I think, off the top of my head, I think it was Morris versus Morris, but...
I can't believe that you can remember all these case laws.
You have to read the updates every week to stay on top of it and what's happening, but that was a case where somebody had instructed their solicitor that they wanted to leave something to their partner, whether or not they became married before he died.
Oh, okay.
They hadn't become married before they died, and the solicitor had drafted the will in a way that the surviving spouse would inherit, and obviously they were not married. And that was the solicitor, I think, making a clerical error. And if it's a clerical error where they've not translated the instructions as per the document, then or not done the document as per the instructions, and there's been a misunderstanding, you can sometimes get it rectified, and then it will stand up as it should have done.
Will writers, solicitors, and down to actually my team writing capacity assessments, writing down the exact what's actually said, those really good case notes, really good treatment notes, capacity reports, things like that. They're going to play a big role in that, aren't they? Because
it's
very evidence.
It's very important. Yeah, the first piece of evidence you would look for in any real contentious probate case is the will file from the solicitors. Once you've seen the actual document itself, the record of the instructions is very, very important. And I think in that case it was difficult because. And this is not uncommon. I think that the solicitor who drafted it had used a tick box form and hadn't completely written down all of the.
I did that.
The thoughts of the testator, but there was just enough there for the judge to say yes. Actually, I think this is what the testator had meant on the balance of probabilities.
We really push on using quotations within our reports because and. We've had people shy away from using profanities and bad language within the reports, but to me that what that person exactly said, down to how they spoke about their son and if they have swore about him, is really, really important because it gives you that context of what they've their emotion they're feeling towards that.
You're absolutely right. It's an insight into their mind, isn't it? I mean, that might just be the way that they express it. You know, they use those certain go-to words to describe somebody because that's the strength of feeling. You can't sugarcoat it. You've got to.
A tick box form isn't going to give you any evidence of that later.
Not always. No. I mean, in many cases, I mean, a lot of people when they make a will, it's fairly straightforward what they want to happen, and a tick box form is just fine in most cases. But it's if there is a complication, if there are difficulties within the family, if they want to do something controversial, or of course if you're in a situation where there's a possibility, and I say a possibility, that capacity could be an issue, that's where detailed notes are very, very important. I mean, it's not the only thing that matters, but it's very much recommended. So, I mean, there are many times where a potential contentious probate case is shut down because the attendance notes from the will drafter or the solicitor are so good and so detailed that it kind of kills the argument that the disappointed individual is trying to raise.
I mean, I'm assuming then, so when you're looking at any contentious case or inheritance tax claim or anything, it's all about the evidence, isn't it? Because
very much, I
keep trying to explain to our team, it's like going back to school, isn't it? You do a mathematical equation, that's great, you've got the answer, but you've got to show your workings out. How did you get to this point?
Of course,
And that evidence, those case notes, those written documents, without that, you can't get to. You can show the answer, but you can't show how you got to that answer, can you?
Yeah, very true. And of course, people do want to analyse things. It's obviously a very emotive time for the family once they've lost a loved one. And if there's something they're struggling to accept in their will or in the way they've dealt with their affairs, they want to know why. And that can sometimes be the driving factor behind the inquiries we get. So that's also quite helpful. I mean, that doesn't go to the core of how can you challenge a will and under what circumstances might it be declared invalid, but it sometimes provides people with the answers they're looking for, which compels them to sometimes take legal action.
So I'm assuming from that point then, going to W.H. Smith's and buying a will writing pack for $9.99, you're not getting any of that, are you?
Well, there's many good things you can buy at W.H. Smith's. I wouldn't want to do them down. And I think
or Tesco,
or Tesco, or any other online service you can get. And
we want the BBC. We don't have to do that.
True. Yes. Well, don't want to end up in Gary Lineker's situation, eh? But
no, that's right.
But there's been a bit of a trend, obviously, for people to start using AI these days. To draft wills, and whilst it's becoming,
so AI may see those cheap $9.99 will kits.
Not necessarily
disappear.
It could see them disappear, or it could see. It could just see basically, I suppose, an instant electronic version of the same kind of thing. I mean, at least a will kit, there's some general framework in mind. I think AI is becoming more and more advanced. If you use ChatGPT to go and create a legal document, I think the accuracy of them is starting to improve
dramatically.
But it's a bit like the way that I see it is, it's a bit like if you try and create a music track with AI. You might get something that's got a melody, it's got a bass, it's got chords, it's got a good drum beat, and it sounds quite appealing. But it's not going to have the intricate brilliance of, say, Case of You by Joni Mitchell or John Mayer's guitar solo in Neon. You can't replicate that top-level quality, and it's the same with will writing. If you've got a complex estate, complex family situation, or you've got assets that need to be dealt with in a particular way, AI is probably not going to crack that nut for you. No. And getting a good will writer, a good solicitor who's got that know-how, that sharpness of mind can sometimes make the difference.
And I think AI is going to have it. It's a tool, isn't it? And I think, because I'm sure there are plenty of will writers out there and other people that are sat there worrying that AI is going to take their jobs.
Yeah.
I don't think it will.
I think
it's a tool the same as Microsoft Word, spelling, grammar. It's things like that. It will speed up what you're able to do. But it won't replace what because you still need to, as you say, sit there with the client and make sure that whether the will's written on Will Writer Pro or Will Suite or any other system or on AI, you still have to make sure that it's everything that it needs to be, and especially in context.
I think one of the things that AI will do is it will come up with the clauses, it'll pull them off, I don't know, Practical Law or somewhere like that. I don't know if it's got access to that, or any other online site where you can get standard will clauses, but it's the ability to make those work for your clients that makes the real difference. Yeah, exactly, to individualise it. And there are certain complex things in wills, like discretionary trusts, for example, that are difficult to create via an automated medium like AI.
Yeah.
So I do think that people need to be very, very careful, because it's a huge thing making a will. It can have huge implications for your loved ones and your descendants after you've died. And a lot of people I know in Britain particularly are rather averse to paying for a service. They think, I don't want to drop a couple of grand on something that I'm not going to see any benefit from immediately. It's natural to think like that, but it could save so much trouble, and it also saves a lot of people from having to deal with the likes of me. Not to do myself out of work.
It's a strange thing to do, isn't it? Making sure that people get capacity assessments done is really important.
Yeah,
but it does you out of work.
It can do. Yeah. I mean,
actually, it's you have to do the right thing because it's the right thing to do.
Certainly, and even in cases where you've done a capacity assessment, it doesn't necessarily mean that that's the be all and end all. But I think definitely if you are in that sort of position that Banks and Goodfellow envisaged, you've got somebody who's politically correct way to say it, but of a senior age, or somebody who is known to have had a health condition that may well have affected their mental health or affected their capacity, or has got some sort of problems in communicating or processing decisions. You need to really recommend very firmly that they get some capacity assessment done before you do a will for them, because otherwise it's leaving the goal open, really, isn't it, for a challenge later. And in some circumstances, to be fair, solicitors and will writers of a certain level of experience will be trusted. If they've met somebody, they can usually tell whether the person knows what they're doing. I think it was Hawes versus Burgess where a solicitor got a reprieve for that, because they were so experienced.
There was one where a social worker had done a capacity assessment, and the judge said, actually, it's not good enough. It wasn't Banks versus Goodfellow based. I think it was MCA based, and it hadn't covered enough. But the judge then said, actually, but based on the solicitor's case notes, that's good enough, and I can evidence that this person did have capacity. Yeah,
it might have been that case, actually, yes. I mean, essentially, solicitors will be trusted to a degree, and so will writers. But at the same time, if you've got doubts, you need to get them investigated, or you need to, at the very least, say to your clients, I have some doubts about it, and if you consider it not in their best interest to have a will because it may well be challenged, those are circumstances in which you can refuse to act.
And that's not just about protecting the client either, is it?
Protecting you as well.
Because we see this, and it is horrible, where we've gone out, we've assessed somebody with evidence that there's massive amounts of undue influence, that the person may have capacity, but actually they're being forced and pressurised into writing their will. And we've contacted the solicitor and said, look, we wouldn't act as a witness to this. We want nothing to do with this sort of thing. This person's a massive influence. And the solicitor has done the right thing and said, thank you. We thought so. We're not having anything to do with it either. And for a fact that person has then been walked down the road to another solicitor's firm, another will writer, to a shop with one of those kits in, whatever it is, and that will has been written anyway.
They found a way.
Because there is ways. And I think it's, no matter how much as a social worker I want to make sure that our clients are protected. It's also sometimes it's about protecting you to make sure that you've done the right things, and you can say, actually, look, we did all the right things, and this has come back to us, sort of thing, but we've done everything right.
And if there's a record of it as well, then it might still be relevant later on. So even if somebody's made an inquiry and you've declined to act, it's worth making a record of it just in case it does become relevant. Obviously, contemporaneous notes of things tend to help a lot more, because with the best will in the world, we can all be called up to court one day to speak about somebody we saw many years ago, but our recollections are not going to be that strong, are they? And then there's a degree of unreliability about that. So, but it isn't unheard of for solicitors' firms or for will drafters to be in the line of fire if they have not followed the proper steps. I would stress that the golden rule is not mandatory But if you've not followed it when there's clear reason to believe that somebody could have
Yeah,
dodgy
if
capacity,
you've got somebody that you
then,
know
you
has
could-
got a diagnosis of Alzheimer's disease and you don't follow them,
Yeah.
then you're leaving yourself open, aren't you?
potentially, yeah. I mean, I think if somebody's been diagnosed with a condition, you've always got to ask them to get an assessment, at least from the GP or from a social worker with that qualification. And to be fair, most solicitors firms will do, and I've even heard of solicitors firms who, when they know a client is going to go down the road, they'll put a call in and say, actually, just beware, we've seen this person, we think
I like
they lack
that.
capacity. So it's putting the alert out, if you like. I mean, you've got to be a little bit cautious and obviously adhere to the code of conduct there. But if you're protecting them from themselves in some ways, then there's potentially a positive case for it.
I mean, you know, we could put safeguarding concerns through to local authorities and things like that, but ultimately, if somebody's very quiet about something and actually it's all written and done underhandedly and silently, there's nothing that you can do to protect that person.
Yeah, and you could say also that, you know, it's up to a different firm, a different will writer to make their own decision about that, whether they think it's the right thing to do for that client, and you know that's the extent of it. So
so at the minute, is there any specific types of cases you're seeing? Because we see it where we get an influx of it, and you're almost going, "This is the same thing. I've done this 20 times in the past month." Is there a pattern that you're seeing at the moment of cases?
Well, I would say that there's a few potential patterns. Yeah, I mean, capacity cases, you're always going to get them because they're so fact specific, and it's actually quite difficult sometimes to work out what the outcome is going to be. So, just to give one example, there have been two decisions that I've read about. I think one was called McCabe, and another was called Birria. And both of them involved the testator operating on the basis of a delusion. They believed that one of their children had done something wrong, wrote a will reflecting that belief. And in one case, the will was declared invalid because it was a totally delusional belief that influenced the way that person thought. The other case, although the delusion played a part, the wider circumstances supported the testator's decision, and it was deemed to be not as crucial a factor, and the will was upheld.
Okay.
So I think we'll see quite a lot of capacity cases because, as I say, that they are so fact specific. A couple of developments we've seen in the last year. There was, as I say, there was that will rectification case that I mentioned. There's also been a couple of very curious ones. There was a deathbed gifts case, which was a little bit of a curveball, I think, because they don't come up very, very much.
They made gifts, lifetime gifts, while they would...
conditional upon this death. I think it's called Donatus Mortis Causa or something like that. But it was a... let me just think of the name of the case. I think it was Rahman and Hassan, off the top of my head, but the chap had left some property to somebody on his deathbed contingent upon his death, but it was upheld because he'd given him physical means of accessing it. Like, this is yours, I want you to have it when I die, here's how to get in. And it also said you can have some money as well, here's the bank password. And that actually effectively takes it out of the estate. So that was an interesting case, and we may see more of those coming up in future.
That is interesting.
Again, that opens the door for more capacity assessment potentially, because capacity to make a will is one thing, but capacity to make a gift is a different test.
Different,
yeah, definitely.
I mean, it was interesting what you were saying about the delusions, actually, because one thing that we teach all of our team is everybody lies, and I couldn't for the life of me figure out where I got this from, but it's from House, the medical show. He teaches everyone it. And I don't mean that everyone's a liar, but either people lie because they don't know they're lying, and their illness is causing them to tell mistruths. Or we get people that are lying because they're a bit nervous about telling you the truth. Or we get people that are lying because they're lying. And what we've found is with capacity assessments is that obviously we prefer to get the truth, and we work very hard to get the truth, but in those cases, actually, you know, you can write down that, you know, this person, we had one client, bless her, she didn't want to leave her money to her daughter because her daughter, it was horrible, murdered people, and hundreds of people in her head. I mean, she was the world's largest serial killer ever. None of it was true, but if we hadn't known that, and that had gone into our report, and we'd said, well, actually, she has got capacity and she's leaving it out, her daughter out because of this reason.
Yeah.
When it come to be contested, I always like to think, well, actually, that evidence is that it was a delusion, and it's very easy to then argue against that. Whereas if you haven't got that written down, and she's just written, well, leaving her daughter out, there's no evidence of her reasoning why she's left her daughter out.
Yes, I'm sure, yeah, and I suppose that's an extreme example, but there can be
I do
other
like extreme examples.
Well, there can be other less obvious examples, and I suppose from your point of view, you've got to be very skilled at reading between the lines, haven't you?
Yes.
You know, and well, one thing I would say definitely for solicitors is that having doubts about someone's capacity and asking for a testamentary capacity report is one thing, but if somebody is expressing a belief that you find a little bit incredible, which is driving their decision to make a certain type of will, it's a good idea to get the capacity assessor to just explore that a little bit with them, so that we don't know
and if we've
whether
got
there's
that
basis in
information
facts.
of is this true or not, then we can discuss that and explore it quite deeply with them.
Yeah, did my son poison my dog or something like that?
But
for
sometimes
example.
the delusions are so believable. I had a client before I worked for Nellie, when I worked for local authority. He was a lovely man.
Yeah.
He was a trumpet player in the 50s, and he was an Olympic skier, and I knew this was all true.
Yeah.
It was all genuine. And then one afternoon he was telling me that he was a Spitfire pilot in the war. I've got no reason to doubt it. It was the right age, everything else he'd done. Olympic skier, trumpet player, middle class, Spitfire pilot, makes sense. And he was saying that he was shot down over the North Sea, but he managed to jump out, parachute down, swam back to land, managed to get in a jeep, flag somebody down, drove to another airbase, got back in another Spitfire and went straight back up. And I'm like, oh my God, you're my hero. You know, this is every boy's dream, isn't it, to meet a Spitfire pilot that does that. It just watched the Battle of the Britain. It was the story from Battle of Britain, and he'd watched it and he'd taken it on board as his own delusion. But because of the rest of his life, unless you went and spoke to people that knew him, you had no reason to doubt this man.
No, true, yeah.
You know, everything else that he'd said was more than most people would dream of accomplishing anyway. So it is really difficult to identify sometimes.
I suppose for some of those sorts of things, you'd have to have a bit of cultural awareness. I've seen that film. So
absolutely. I'm sitting going, I know this story.
But if you've noted it down, obviously, then people who did know them and will know whether it's true or not will be able to immediately say.
And I think that's the really cool thing, and the important thing when it's whether it's capacity assessments or case notes, I suppose. If all of that's written down, then actually you've got evidence later down the road to argue why you've come to your decision, and actually whether that decision was right or wrong kind of goes out the window, because you've shown your workings out.
Absolutely, yeah, and that's all you can really do sometimes. I mean, you can't tell people what to do, but you can certainly make a good record and explore it fully and give those who do have an interest the full facts. So it's invaluable, definitely.
So contention around delusions, which sounds quite intriguing. If you keep an eye on our website, I'm trying not to sell, I try not to, but keep an eye on our LinkedIn and our website. We have got a brand new service coming out at the end of April that will hopefully overcome all of the concerns that you've just raised. Hopefully, fingers crossed. It will.
Look forward to seeing that. Yeah.
I know it will. Is there anything else that's sort of jumping up at the moment and going, oh, that's of interest, that's new, that's exciting?
Well,
it sounds horrible saying exciting, but
exciting to contentious probate lawyers and exciting to the wider world can be two very different things. So the case that you'll have seen loads of us talking about in the last few months is Hirachand, which is all to do with costs, really, to be honest. So I won't go into that in any detail, but essentially it's about no win, no fee, and whether you can recover success fees. That's going to obviously have a big impact on Inheritance Act claims. To do with contested wills, I suppose one thing that I will always chews away at me a little bit.
Sorry, no, you skimmed over no win, no fee.
Okay,
So is that?
I'll go back if you like.
I'm intrigued, and I'm sure some of our viewers will be. So is that potentially, could that I mean, what impact could that have on no win, no fee?
Well, to be honest, we've gone back to how we were before. So it's actually the previous decision in Hirachand was going to have much more of an impact. And I think for 2 years, it was the case, as decided by the Court of Appeal, that if you've brought an Inheritance Act claim basically out of financial need, and the only way you could bring that claim with legal representation was to get a solicitor to act on a no-win, no-fee. When you do a no-win, no-fee, as you may be aware, you have to pay a success fee at the end, which can be anything up to 100% of your solicitor's costs.
Okay.
Because obviously they've acted for nothing with the risk of losing, and that's kind of a reward for having won or successful outcome. And the judge at first instance actually awarded, I think it was £16,000 towards the success fee on top of the amount they get from the Inheritance Act claim, because the claimant obviously was going to have to pay that to their lawyer, and that would negate the benefit of bringing the claim to a degree.
Because the only time I've ever used no win, no fee is for PIP, and not PIP, we've got a car claim going through at the moment for the dodgy sales that they did.
Oh dear, right.
So they take 20. If I win £1,000, they take 20% of it, and then they can reclaim their costs on top of that. Is that?
Well,
is that kind of what was
sort of, yes. I mean the use of no win, no fees in contentious probate is not that common, but it comes along every now and then. Inheritance Act claims is an obvious example, because the people who bring successful Inheritance Act claims tend to be people who are broke or have got rich to their name. So there's no way they can afford to pay tens of thousands of pounds to run a case to trial with solicitors and barristers, and that's why they tend to get offered.
Let's say the inheritance tax claim is successful. The client wins £100,000. They then have to pay the 20%. Or whatever
the percentage is to the solicitor, because it's not recoverable any longer from the other party. The solicitor is then able to claim a success fee from the other party as well. Well, usually if you win a case at trial, you will be awarded costs, but you won't be awarded the success fee. And Hirachand reversed that initially, but then it went back late last year.
So they can't.
So now it can't be, because it was essentially seen as, in a nutshell, a way of trying to get extra costs through the back door, whereas costs are decided separately, which is why it's not been upheld, that decision.
So but it was trying to get double bubble.
I think it would have opened the door much wider for more Inheritance Act claims, because there are people who will obviously look at the possibility of it, but then be put off by the fact that they will have to pay out quite a bit to their lawyers if they win at trial, and they do it with no fee. And sometimes it's worth the benefit if it's a big estate and they've got a good claim, but sometimes if it's a more modest estate, it's not.
See, now you've made me think. Going back to what we were talking about, I told you there wasn't going to be a set talk on a set pattern of this. Thinking about AI and what you were saying about earlier, I heard a great science fiction author talking about AI a little while ago, and he said everybody's worried that AI is going to come along and take your job. He says it's not going to happen. He says if you go back to the first piece of technology invented, the plough, he says we were all told that once you've got a plough, you'll have more leisure time, because it'll be quicker to plough the little bit of land you've got. He said, and that's not what happened. We ploughed more land and we grew more vegetables, and you work just as hard. He said, and every time we've had an advancement in technology, we're promised this will give you more leisure time, and actually it just increases productivity. And you work harder. Self-checkout tills are a great example, aren't they? It will save you time at the till. Yeah. But you're going to have to work to do it. Yeah. Instead of you standing there and having a chat, all of a sudden you're physically having to work harder.
Well, perhaps, yeah. I mean, you could argue it's taken away some people from the checkouts, but
if there's a possibility that there's going to be more probate cases, more inheritance tax claims, more legal work going on.
From AI wills.
Potentially from AI wills, but also the speed that solicitors, paralegals are going to be able to work is going to be faster. In 10 years' time, are they going to be able to take on more? At the minute, a solicitor's firm will say, I'm really sorry, we can't take on your case, we're too busy. Is that speed going to see it?
Is it going to speed up as a result of AI? Well, it's a bit... I'm sceptical, really. Yeah. I mean, I think that many solicitors will agree with this, but trusting essentially a separate entity to do your written work for you is a very risky strategy. I mean, time is obviously a big factor, but we do check and double check and treble check everything.
I do wouldn't
because you do not want to say the wrong thing in a formal document.
Microsoft Word started doing grammar and spelling checks if the same conversations were being had.
Maybe, but yes, I mean, you still read through everything, don't you? So I'm not sure it's going to speed people up that much or open that many doors, but I do think contentious probate's been a growing area for quite a while now, and it is going to continue to grow. I mean, I think it's partly societal and generational. We've got a generation of people at the moment who maybe bought council houses in the Thatcher years and are starting to pass away, and there's actually an estate to go at, whereas 30 years ago a family in a similar sort of situation may not have had very much to their name. And
I suppose that's the same with will writing though, isn't it? If you go back to my great-grandfather's time, he wouldn't have had a will. The only thing he had to leave was a pen and a paintbrush, maybe a pocket watch, and that all went to his son, or his eldest son anyway. It's just the natural course of things. Whereas my granddad, like you said, he had a council house that got sold and split up between his children. My parents have got something that they will pass to me, although I keep telling them, please go and don't blow it, spend it, go and get drunk.
Absolutely, yes.
But I do find, I don't know about you, I find it weird that we're obviously living longer now, so we're seeing people that are in their 90s, maybe 100 years old, and they've got children in their 60s and 70s, and they're desperate. The level of abuse and undue influence that they're placing on their parent to get hold of that money. And we see people that are placed into care homes that are not the best care homes, solely to protect inheritance tax down the road, and awful things like that.
Yeah.
And I just keep thinking to myself, if I get to 70 years old, and I need my mum and dad's money, there's something really gone wrong with my life.
Well, I think yes, need and want are two very interchangeable terms to some, aren't they?
It's this strange thing that we've got now that when somebody gets to a certain age, not everybody, but certain people seem to go, that's now my money. My mum's in her 80s, so all of the money that she's got should now be mine. Whether she's alive, whether she needs it for her care, I find that societal change in the past sort of 30, 40 years has been so strange.
Well, it's possibly the case that they've seen other relatives or their parents inherit at a younger age and think, when's it going to be my turn? I don't know. But there are also examples of families where there's been a promise of inheritance eventually, and it doesn't materialise. And obviously there are some people who I think are desperate to try and save more of their money so it A, doesn't get taxed, and B, doesn't get swallowed up in care.
Because they're just living too long.
Well, yeah, and the thing is, I think it's been said that almost half of us may end up getting dementia or Alzheimer's to some degree if the life expectancy stays as high as it is. Yeah. So inevitably there will be care that most of us need at some point in our later days, and that does cost money, and someone's got to pay for that. Yeah. So yeah, there could be an element of that amongst people's thinking, I guess. But generally speaking, I mean, a lot of these contentious probate cases, there's an awful lot of family politics at play, and I think you can sometimes say, well, yes, there's been some bad behaviour from typically one of the children of the family, or there's been disharmony if there's a blended family, for example, don't like the new spouse of one of their parents, and vice versa. But there are sometimes more complicated circumstances than that, and it's not all a money grab. I mean, it's tempting to think that might be the case because it's how it's put across by a lot of the media in this country.
Yeah, and I think you're right when we've got blended families, we've got second and third spouses sometimes, and there could be children from all three relationships.
Absolutely, yeah,
and understanding the family dynamics when you're writing a will and having an understanding of it, or assessing capacity, or contesting it later down the road, you almost have to map it out. You almost have to do genograms and to understand actually who are all these people, because you're given the names, aren't you? And it's huge.
And it just doesn't hurt to do a family tree sometimes just to get it right in your head, because and this is obviously where making a will in the right circumstances is so important. Yeah. And you've got obviously the fact that you need to provide for those people in the right way with the estate that you have. But also the fact that there's a high chance of there being somebody who's disappointed, starting a bit of an argument off. And if you've gone through those proper steps and had that high level supervision of the way you've managed your affairs, there's less chance of that happening. So Again, slightly doing myself out of work by saying that, but it's the advice I'd give to all the people, really, if you step out of that circle.
Stepping sort of, I suppose, further down the process to being in court.
Yeah.
Because we often get asked, are you okay to attend court if necessary? And we always say yes. But are courts, especially after COVID, I suppose, are courts wanting oral evidence, or is it actually written evidence, case notes, document? Is the weight on that oral evidence? Because, like you said, memory is for most people is atrocious. So giving out oral evidence, I mean, we always say, well, we can only tell you what we've already written. You know, oral evidence is fine, but I can't give you really anything more than that because I haven't seen your client for 3 years.
True, yeah. I think the answer is, and lawyers always say this, but it depends. I mean, if you're talking about a witness of fact who is bringing up their recollections and, you know, essentially, this is how I remember the deceased, this is what the deceased said, this is what the deceased did, you want to hear from them directly, oral evidence. They'll do a witness statement, but the goal is obviously how do they cope with cross-examination, and you know, when their evidence is challenged, how cohesive is it? Does it is it cast into doubt when they're grilled by the opposition advocate? And the same to a degree can be true for capacity experts. And it's not that you're not trusted; it's just that obviously
you're trying to win at the end of the day.
Yeah, the lawyer's trying to win, and also there are some cases where you get disagreement. I mean, you can get very esteemed capacity experts at the top of you know of that profession, like Professor Jacobi was, or like Dr. Hugh Series, for example, and they may come to a different conclusion based on historic medical notes, based on other bits and bobs of evidence that have been put before them, and you'd want to hear all evidence from them. But generally, yes. I mean, if you've done a report as an expert and you've got the expertise, you've gone through all the relevant facts that can be presented before you and given an opinion. So, it guides the court, but it doesn't necessarily determine the outcome. It's still the judge's decision.
Often the will right is pulled in to give oral
it can be, yeah. Certainly can be. I mean, they may not remember, and it's not a criticism, it's just that you see loads and loads of people, you can't always remember each one, and it's quite possible that your recollections of 2 or 3 of them could intertwine a little bit, and that's natural. But I think, yes, if you've done a will file and there are things in it that need to be questioned or explored, it might well be the case that, yes, you're called in to give oral evidence.
So even if you're a will writer doing 2 wills a week, self-employed, you could still end up being pulled into a courtroom.
You certainly could, yeah. I mean, the odds of a case going to trial are still fairly slim. It does happen. We get reported cases all the time, but the majority of cases we deal with end up settling at some point. If you've got an arguable case on both sides and there's risks, people realise that economically, if they go to court and they lose, then it could be devastating for them because they've got to pay not only their own lawyers but the other side's.
Of course,
that's the natural consequence in most cases. There are examples where that doesn't happen.
So you might retain your inheritance, but potentially lose all of it.
Well, you could lose all of it, and you could end up being faced with a huge crippling bill and the crushing disappointment of a judge not agreeing. But there are some that can't be settled very easily. I think every case has the potential to be, but if there's a difficult point of fact or point of law that needs to be determined, it sometimes is the case.
So a lot of your work is out of the courtroom itself and that advocacy and working on compromise, I suppose.
Most of the work we do, yes, is outside of the courtroom, but obviously there comes a time in most cases where you end up before a judge, and it might just be for an application hearing or a directions hearing, but it could sometimes be for final hearing, and it's a rarity amongst the cases we take on, but it's a very high possibility, and you've got to always be prepared for it.
See, I mean, as if you're a local authority social worker, things like that, a lot of the time the reason that you're giving oral evidence in court is because you haven't had time to write up your report. And so you're the judge. You've got no choice. The only way you can give that judge in a family court setting or something like that is, poor child protection social worker with 40 cases and been working till 11 o'clock at night, walks into a courtroom at 9 o'clock in the morning, and the judge says, "Where's your report?"
Yes.
I've got to give it more. So for social workers, it's I suppose a different context.
I should be a bit less hard on them. I mean, we've
sorry, Fumi, just pass me something.
We have quarter protection cases where things do get delayed from that side of things. Obviously, as a solicitor, you're chomping at the bit. I want to know what's going on, but obviously they're very overworked, under a lot of stress, and it's a very difficult and important job that they're doing. And yes, a bit of empathy from our side would probably be a bit more welcome.
I think as a private social worker, we can get frustrated with local authorities and social workers and nurses and doctors and everyone else who works
and solicitors, no doubt, as well.
But sometimes you have to sit back and go, do you know what? I've got a nice office, and we've got a coffee area, and we've got a
very comfortable sofa. I will say,
and things like that. And you kind of have to remember. Actually, I remember working for the NHS, and it is a full-on slog sort of thing. Yeah,
absolutely. Yeah.
So, sorry, my brain's just gone, and I'm trying to read my notes. That section, I don't know where this came from. The golden rule. Do you think, because originally it was an aged or ill contestant should receive a medical practitioner to sign it on?
Yes.
Obviously, the medical practitioner has gone far by the wayside, because the chances of getting a GP to do a testamentary assessment, to even understand what Banks versus Goodfellow is.
Well, many of them don't know a lot about it, and you do sometimes get GP reports that are 3 or 4 lines. Yeah. I tested this person, I'm satisfied they had capacity.
Letter of determination.
Yeah.
That's the one that I heard recently.
It's not always very helpful,
No.
And they are, as I say, open to challenge. And then, of course, your GP probably won't remember. They'll have seen somebody for a 10-minute appointment before 25 other people that morning.
Let's be honest, you're not going to see your GP, you're going to see a GP that, we haven't got our family doctors anymore, have we?
Yeah, and it's somebody you might not have seen before, because obviously, if, the staffing changes and so on, and somebody's on shift one day and not on another day, it can be a bit of a lottery. I mean, I don't know if ever I've had to go to the GP. You have to phone up at 8 o'clock, and it's potluck whether you get through or not for an appointment that morning. And then they'll say telephone only, and it's at,
I found out. Do you know why?
Any time between 12 and 3.
Do you know why they do that?
No.
Because if you ring up and say I need to see a doctor, and then you go onto their list, they have to see you. And if they don't, they haven't hit their KPIs. Whereas if you ring up and, I'm sorry, all the appointments are gone today, you're not on today's KPIs, you're on the next day, or the next day, or the next day. So then they can say, look, we hit 100% of our KPIs.
I see.
It's literally just a tick box exercise to say, look how brilliant we are. But I think they're talking about scrapping all of that, aren't they?
Well, they may well do.
But
yeah, I think the term medical practitioner in Kenwood Adams, it's got to be interpreted much more broadly than that. And to be honest, it's sometimes better quality if you go to established capacity experts. In fact, it's quite often better quality, isn't it? Because you do them all the time.
What we do.
You're not seeing somebody about a cough and a cold and a strained wrist, and then seeing somebody about capacity. It's your bread and butter.
Do you think the golden rule is still viable? Because is the aged thing, is that still relevant?
I suppose it is in a way. It's, as I said earlier, it's not maybe the most politically correct way of dividing people up, but I mean,
but there has to be a line in the sand.
Yeah, the question is, where do you draw that line? I guess. I mean, I don't know, if it was perhaps somebody of working age who comes in, you would assume, wouldn't you, naturally, that they know their own mind. They might not. I mean, it could be the case that they've got some mental health issue, or they've got some sort of
ABI, or
who knows? And then again, there are people who've been retired for 20 years who are as sharp as ever. You can't judge people by their age, but I think that the solicitor or the will writer just has to make a judgment call to the best of what they see, the best of their ability and experience. And if there's any doubts, then I think that you do need to just sort of say, look, I just feel more comfortable if we did a capacity assessment. Would you be open to that? And if it's one of those cases that isn't as obvious, you then have to take that judgment call. Do I continue with their instructions, giving them the health warning that because you've declined a capacity test, you don't want to pay for it, or you're offended at the thought of me asking for one, which is understandable. I can still do this will, but it could be open to attack if there's anything dubious about it. But obviously, if you're not satisfied yourself, then you've got to remember that you have to act in a client's best interest, and is it in their best interest to make a will which could be torn up or could upset a lot of people after they've gone, and tie up their estate in litigation.
So that aged and illness is still
it's still relevant, but it's not. It's difficult to place an exact line in the sand. And as I say, if somebody's a day younger than 68 doesn't necessarily mean that they should be treated differently to someone a day later.
No.
Because
that's the thing, isn't it? I mean, I see I see 70-year-olds that aren't little old men and little old ladies. They're young. Yeah, they are. They're still going mountain biking at weekends, and they're going off and doing things.
Absolutely,
turn
my
around
parents
to
are
somebody
still
like
skiing
that and
every
say,
day.
turn around to them and say, well, "You're elderly now." They'd be quite insulted, sort of thing.
Absolutely.
So I think is it down to the individual? I suppose is this person presenting as aged in the fact that it's impacting their cognitive function, the way they're thinking. Are they showing signs of age impacting on them?
I suppose so. I mean, I don't know. I think one thing I've found quite helpful is when I've spoken to private client solicitors who I work with, and they'll have general discussions with the clients about I don't know, something that's been on the news that day, for example.
Yeah.
And or might tell them a fact about themselves and then see if the client remembers it, and that's a good way of sort of sneakily testing.
Yeah, we like to do distraction techniques.
Yeah.
We'll be talking to them about their will, and then we'll randomly start talking about other things for 3 or 4 minutes, and then see if they can come back.
Yeah.
And a lot of the time somebody can, but what we then see is they'll be telling you the same thing they've just told you for the first time again.
Of course, yeah.
And that's the hang on a second.
And memory's not the be all and end all, is it? I mean,
no.
There's been criticism of just using memory tests, which I think some GPs still do.
Yeah.
It's about also the executive functions of the brain. How do I deal with information?
Yeah.
Or where have I got information from? Going back to the delusions point. So it's a minefield, really. And I think that essentially, if you've got you're satisfied in your mind that somebody who is of an elderly disposition, you could say, I don't know a better way of saying that, and you feel they've got capacity.
I think people are still allowed to be elderly, aren't they?
Of course, yeah. But you need to write down why you think that is. You need to detail, look, I spoke to them about this, they seemed completely on the ball with it. They knew their own mind, they gave good reasons, I explored those reasons a little bit, it seemed to make sense to me. It might still be that somebody is operating on the basis of delusion, but if it's not immediately obvious to you as a practitioner and you've taken reasonable steps to try and investigate it and you're still satisfied, it's hard for anybody to turn around and say to you, you've been negligent, you're liable, because at the end of the day you have to take people as you find them, and
absolutely
you seize people for 20 minutes, half an hour, you can't know everything about their lives.
And we've had these conversations with people where they've rang up and they've said, but you didn't know this, and this, and this. I'm like, that you're right, but we're not investigators. We can't start contacting the banks to find out how much money they've got in their banks. We can't contact adult social care to find out, are they receiving care? We can't start ringing every solicitor in the country to find out whether there's a deputy.
Of course,
you can't. There's only so much investigation that anybody is allowed to do, and rightfully so, because how much of that could then prejudge you? We're coming up to an end, but I just you made me think actually about what you were saying when we were talking about the golden rule, and how it's about sort of working with the person, and it then made me go back to the beginning of all of this when we were saying about the interface between the Mental Capacity Act and Banks versus Goodfellow, and actually the principle of the MCA, which is to support the person to make their own decisions. And you're absolutely right, with memory, it should never be a memory test. Because if you can sit there and you can find other ways of giving that information to that person so they can understand it, and retain it long enough because it's written down in front of them or drawn out in front of them, then actually it's really important to support that person. Banks versus Goodfellow, the MCA, should never be about taking away their capacity because you've got the power to do so. No,
I think it's really just though ensuring that people have have had the test that they need, or been to see somebody who's got a bit of expertise.
And all of your information is recorded.
Yeah, exactly, because you owe it to not only the client but also to their family, their beneficiaries, because if they're making a will, they're maybe losing a little bit of their mental faculties, but not to the point they've lost capacity, but they're trying to do it for the right reasons and trying to provide for the people they want to provide for, and we do have testamentary freedom in this country as a principle, then you want to try and help them do that. So you just need to make sure that obviously you're doing something that is going to stand up if challenged, and of course that you're not in any way causing problems for the testator or for their family further down the line, which could come back to bite you.
So, key tips, case notes,
without a doubt. We're try and have a general open discussion, record things that are said. Any doubts at all, you've got to raise the issue, even if it might risk offending the client. You've got to still raise the issue, and then I think always try and see a client alone if possible, because although we've not spoken about it much today, undue influence is another way, obviously, in which people can challenge the validity of a will. And if a beneficiary who's going to get a handsome amount of the estate is taking them to the meetings, possibly doing the talking for them, it's a possible red flag. So try and see your clients alone, and you've got to explain it to them that their instructions come from them, it's their estate, and that you've got those professional obligations to ensure.
That goes back to that principle too, doesn't it? It's about supporting that person and reassuring them that you can make your own decision here. You don't have to do as this other person is telling you, and I'm here for you.
And I think I'd also just say as well, I mean, partly out of guilt perhaps, but if a will that you have made is being challenged and a solicitor is sending you what appears to be rather hostile correspondence saying, we want to see your file and ask you these questions, please don't take it personally. We're acting for a client who's got some doubts, and it's not necessarily a reflection on what you've done or not done. We're just trying to get to the bottom of it. And sometimes if we get to the bottom of it and it's apparent that the person had capacity, they weren't being manipulated or influenced, and they've just made a choice, and it's a choice which might have upset our client, but there's no legal means to get around that, then fine, you've helped, you've at least answered the question for them, and we've saved them the time and the money of going to court on a fool's errand. But obviously, if there are things that are wrong with it and you couldn't have possibly known of that, then it's still a viable case, but it doesn't mean that the will writer has got it wrong necessarily.
I think it's lovely to say that for you to tell everyone not to take it personally. They will.
It's natural to do that. We all take pride in our work. I understand that. And, but you've got to bear in mind, we're given a very different narrative if somebody wants to challenge a will, or if somebody wants to defend a will that's been made by a relative. That's their case, it's through their eyes only, and not necessarily through the eyes of you or your client or anybody else. But we've got an obligation to that client to do our best for them. So
absolutely.
Okay.
Have we got any questions for me?
Not presently.
Not presently.
No? Okay.
Fabulous.
Happy to take them by follow-up.
If there is any questions, please do send them through.
You can find both of us on LinkedIn as well.
I follow Lewis on LinkedIn. You're quite prolific on LinkedIn.
Well, I like to post about the fun side of the job, definitely. There's lots of outings, like today, for example. Nice trip to Grantham, and very comfortable sofa. My kids would love this, with the toy elephants. And everywhere we go, I have to have a really tough negotiation with them about not buying loads more stuffed animals.
To be fair, we probably elephanted ourselves out now. We have so many elephant things.
I've been very tempted to make an elephant in the room joke, but
no,
save the dad jokes for later.
We don't talk about
that.
Fabulous. Thank you, genuinely.
Thank you. It's
been lovely talking to you. And please join us next month. We're going on the road next month, aren't we? No, we've got Dave Lockwood from Finders International coming to talk to us about Finders International. I've just completely forgotten what Finders International do. They're genealogists, so that they look at and get money to people that deserve it after you guys have,
Yeah.
either not, actually not.
We've
been no
used a
more
few
before.
genealogists in the past, actually. Yeah, it's
So Dave's coming on. If you know Dave, you know he's always a good person to sit and listen to. So please do keep an eye on our website and LinkedIn and follow Foon Me, because she'll be posting about Nellie on the sofa next month as well. The month after that, we're going on the road.
Going to Bristol.
We're going to Bristol and we're meeting, and I want to say this lady's name right. I've known her for years and I say her name wrong every single time. Heleth Gwyn.
Yeah.
We've got Heleth Gwyn coming on, who is
I
like,
also follow her on LinkedIn. Yeah, she posts some really interesting stuff.
yeah, she's one of the top legal influencers on LinkedIn now.
Yeah.
It's amazing. Yeah. So we've got some really good guys coming up. Please go on to the website and go on to NellieCon. Get your tickets for NellieCon. We've got some great speakers, fantastic speakers. Fumi is also organising panel discussions and all sorts. And we're going to have a magician this year.